We'll see if YouTube is happier. Don't worry, Aaron, you're going to get your video. We're just going to try this experiment. I've been wanting to experiment on YouTube. Well, I guess we'll do it now. Hey, hello there, YouTube. Paul Engel here with the Constitution Study. Mute myself so I don't get in the middle. I'm glad you could join me. You can actually thank the fact that Facebook isn't working today. I figured I'd try doing this live on YouTube. So if you're watching this, if you catch this, you get notified, watch this live. Hey, thank you very much for subscribing. Thank you very much for being around. I like to say everyone over to my page, constitutionstudy.com, so you can find everything that I'm working on. If you are watching this on YouTube, I'm going to ask you, if you have a question, stick it in the comments. I always save time at the end to make sure I can answer your questions. So I will try to do that. Again, just stick your questions in the comments. I'll take a look at those at the end. If you're watching on the Zoom broadcast, in the Zoom meeting, I do ask you two things. One is, please mute yourself. You don't want too many interruptions while I'm going through this. I will have time for questions. And if you're on Zoom and you can ask your question, let me know. I actually want to talk to you. I love the interaction of Zoom and face-to-face, so it'll be a little more interesting. I know I have one person on the Zoom cast, as I mentioned, and in fact, I'm going to post a note here over to my friends at Facebook, because I've been trying for over 15 minutes to go live over there, and it didn't work. So here we are on YouTube. If I accidentally call you Facebook, I'm sorry. I'm still getting the hang of the new system. So also, I live in Middle Tennessee. It's August. We get thunderstorms. There's a thunderstorm going through, which means you might hear some thunder in the background. You might hear some rain in the background. There is an outside possibility the power might go out, but so far so good. We haven't had that problem. Today, I want to talk about forced vaccinations. Now, with all the discussion lately, all of the restrictions that government's been placing on us due to COVID-19 and everything that's going on, we really shouldn't be surprised that more is coming. In fact, it's quite obvious that once they approve a vaccine, or at least once the federal government approves a vaccine, many states and cities will attempt to force their citizens to be vaccinated. During the debate that's bound to happen, many are going to point to a Supreme Court case called Jacobson v. Massachusetts, and that they will say that that's proof that state and local governments have the legal authority to enact such laws. So before the vaccination hits the fan, let's take a look at this case and truly try to understand the underlying law. So let's start with a little bit of background. It's a 1905 case, Jacobson versus Massachusetts. It actually started in 1902 when Mr. Jacobson refused to comply with a mandatory vaccination order from the Board of Health of Cambridge. See, apparently smallpox was prevalent and it was spreading throughout the city of Cambridge, Massachusetts. The Board of Health of Cambridge ordered that everyone be vaccinated or revaccinated. Now, Mr. Jacobson refused, and he was charged under the revised laws of that Commonwealth, which provided that, actually, hang on a second, let me bring up some, that's the wrong one. Let's bring up some pretty quotes for you so that everybody can see. Whoops. Yeah, I'm having one of those days. Let's see, there we go. We're going to share my keynote. Great, now everybody can see all the quotes I'm going to bring up because you know me, I love quotes. So according to the law, it provided that the Board of Health of a city or town, if in its opinion it is necessary for the public health or safety, shall require and enforce the vaccination and revaccination of all the inhabitants thereof, and shall provide them with the means of free vaccination. Whoever, being over 21 years of age and not under guardianship, refuses or neglects to comply with such requirements shall forfeit $5. Now, after being found guilty by the trial court and failing his appeal in the Supreme Judicial Court of Massachusetts, well, Mr. Jacobson appealed to the Supreme Court of the United States, claiming violations of both the preamble and the 14th Amendment of the Constitution of the United States. Now, I found several issues with the process documented in the opinion. Still, the underlying question is, what does it mean to be deprived of liberty? See, I've written before about liberty, and I've spoken on it on these channels. But since it is so important to the understanding of this case, it's worth a brief summary here. Sorry. Webster's 1828 dictionary defines 3 different levels of liberty. If my notes will work. Now, liberty is freedom from restraint in a general sense and applicable to the body or to the will or mind. So in general, liberty is freedom from restraint, any restraint on your body, any restraint on your mind. Noah Webster goes on to state that a man enjoys liberty when no physical force operates to restrain his actions or volition. Now, natural liberty consists of the power of acting as one thinks fit without any restraint or control except from the laws of nature. So natural liberty is a state where the only control on your actions are those of natural law. Natural laws are those that are so obvious, just so part of the human psyche, that they don't really need to be written down. I like to summarize them as don't hurt people and don't take their stuff. Now, civil liberty is the liberty of men in a state of society or natural liberty, so far only abridged as restrained as is necessary and expedient for the safety and interests of the society, state, or nation. Now, civil liberty is where we have to look, see, when we are discussing this case. See, natural liberty is generally a restraint we put on ourselves. Civil liberty is an external restraint put on us. For that reason, it is limited only to that which is necessary and expedient for the safety and interests of society. But what happens if civil laws are created which are not necessary for the safety and expedience of society? A restraint on natural liberty not necessary or expedient for the public is tyranny or oppression. So the natural question is, who decides what is necessary and expedient for the safety and interests of society? Which leads us to some pretty bad state law, which is why Noah Webster noted his definition of tyranny. So you remember that revised laws of the Commonwealth I quoted? Quoting the Board of Health of a city or town, if in its opinion it is necessary for the public health or safety, shall require and enforce the vaccination and revaccination of all inhabitants thereof, and shall provide them with the means of free vaccination. Yeah, the first problem we run into is the fact that the people of Massachusetts, through their representatives in their state legislature, granted the power to these boards of health in each and every city and town to determine if vaccinations are necessary. See, there is no requirement for probable cause, due process, or even a review of the order of the board. Now, I'm sure it wasn't the intention of the citizens of Massachusetts, and I'm sure it wasn't sold to them by their legislatures as such, but they handed over their sovereign decision about what to put in their bodies over to their city governments. And they did so without placing any checks or balances on that power. Now, why should you be concerned about this Massachusetts law, even if you don't live there? Because I expect that every state in the union has one of these laws. That's correct. Your right to determine for yourself what is and is not appropriate to put into your body has been handed over to a bunch of bureaucrats, and you have no due process protections. Or do you? The opinion of the Supreme Court noted that at trial, Mr. Jacobson made several offers of proof that the trial court ruled immaterial. Now, while I recognize the desire to not draw out a trial with the recitation of irrelevant facts, I'm always suspicious when a judge prevents a defendant from presenting evidence. See, there are numerous examples of judges excluding relevant facts because they're inconvenient for the state or do not comport with the previous opinions of other judges. What the opinion does not give is a clue as to what these proofs Mr. Jacobson offered were, though I'd be very interested to find out. Maybe that's a fodder for another article. Now, Mr. Jacobson's claim that this law violated his right to be protected by both the preamble and the 14th Amendment of the Constitution of the United States is where we're going to go. And as the court noted, there's a problem with that first assertion. Quote, the United States does not derive any of its substantive powers from the preamble of the Constitution. It cannot exert any power to secure the declared objects of a constitution unless, apart from the preamble, such power be found in or can properly be implied from some express delegation in the instrument. Now, the court is correct in that the preamble of the Constitution is just an introduction, and it is something to state the reason and intent of the law. The question of the 14th Amendment, however, is something different entirely. See, from the court, the opinion, the liberty secured by the Constitution of the United States does not import an absolute right in each person to be at all times and in all circumstances wholly free from restraint, nor is it an element in such liberty that one person or a minority of persons residing in any community enjoying the benefits of its local government should have power to dominate the majority when supported in their action by the authority of the state. Well, again, the court is correct in that the liberty secured by the Constitution is not absolute. However, it is wrong to state that one person or a minority of persons may not exercise their liberty in contradiction to the majority. The very reason we have a Bill of Rights is to protect the ability of the individual from the control of the majority. The 14th Amendment was created to protect the rights of the individual and the minority from being dominated by the majority. The question is, what are the limits placed on government to restrict a person's liberty? Well, the answer is clear in both the 5th and 14th Amendments. From the 5th Amendment, no person shall be deprived of life, liberty, or property without due process of law. And from the 14th Amendment, nor shall any state deprive any person of life, liberty, or property without due process of law. That means the only way governments are allowed to limit or deprive you of your liberty is via due process. Due from the word meaning owed, and process meaning, well, the course of a proceedings. This is summarized well by the Free Legal Dictionary. Due process is an established course for judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. The question at hand in this case and in all other cases of vaccine mandates revolves around the question of due process. Did the legislature of the state of Massachusetts follow due process when they handed unlimited power to force vaccinations to the town and city boards of health? Did they follow a governmental proceeding designed to safeguard the rights of the individuals? I say no, and for several reasons. See, first, by placing the decision about vaccinations in the hands of unelected bureaucrats without any form of redress, they denied their citizens a fundamental right to question the actions of their government. Article 5 of the Massachusetts Constitution reads, all power residing originally in the people and being derived from them, the several magistrates and officers of government vested with authority, whether legislative, executive, or judicial, are their substitutes and agents and are at all times accountable to them. See, the Massachusetts legislators violated the Massachusetts Constitution by denying their citizens the ability to hold their agents accountable. These laws deny all of us the ability to seek a redress of grievance by placing the decision about vaccination outside of our control. Second, these laws authorize the assault on innocent citizens, not based on anything they have done or any probable cause they are a danger to others, but based solely on the opinions and fears of others. This not only violates the constitutions of the several states, but the Fourth Amendment's protection against unreasonable search and seizure. We'll talk a bit more about reasonableness later. Now, third reason is since those requiring the vaccinations are subject to the sovereign immunity of the state, they cannot be held accountable for any injury or loss incurred due to the forced vaccination. That's right. If you get a vaccine, if you're forced to get a vaccine from your state and you get sick or someone in your family dies, you have no right to sue because the state has sovereign immunity. Let's go back to the opinion. The police power of a state embraces such reasonable regulations relating to matters completely within its territory and not affecting the people of other states, established directly by legislative enactment, as will protect the public health and safety. Now, before we go, We should talk about about the idea of something being reasonable. See, something is considered reasonable if it is governed by reason. From Webster's dictionary, reason is a faculty of the mind by which it distinguishes truth from falsehood and good from evil, and which enables the possessor to deduce inferences from facts or from propositions. So let's take a reasoned look at vaccination regulations. The place to start is the actual purpose of delivering the vaccines in the first place. Again, from Webster's 1828 dictionary, we read that a vaccine is a preparation of killed microorganisms, living attenuated organisms, or living fully virulent organisms that is administered to produce an artificially increased immunity to a particular disease. So the purpose of a vaccine is to produce or increase the recipient's immunity to the disease. See, governments who call for mandatory vaccines do so stating their goal is to stop the spread of the disease. Whoops, where'd my... Oh, my notes went away. Oh. Hang on. Sorry about that. My notes for you disappeared. I'll have to catch up with those later. Okay. Quote, whereas smallpox has been prevalent to some extent in the city of Cambridge and still continues to increase, and whereas it is necessary for the speedy extermination of the disease, ... See, what are these health boards really saying? Notice they do not provide evidence of the efficacy of the vaccine in question. They don't even claim that their goal is the safety of the individual. Their goal is to exterminate the disease. Now, while that may be a laudable goal, is it reasonable for someone to take a potentially harmful, even lethal treatment without informed consent? These boards of health are basically saying, you are too stupid to make this decision for yourself, so we are going to make it for you. If we do not allow doctors to administer potentially dangerous medications to their patients without analyzing and reviewing the danger with them first and obtaining their consent, why would we consider it reasonable for a bureaucrat to do so? History has shown that there is a certain number of people who will react badly to any vaccine. Some will even die. Does the state have the authority to tell you that you must take that risk? See, while the power to establish health regulations is a power of the states, the question remains, is it reasonable for the state to impose what it believes is best for the people without their input or any consideration for their individual situations? And since the purpose of the vaccine is to increase the immunity of the recipient, how does someone not taking the vaccine endanger those who have? Yes, there will be some percentage of those who take the vaccine that could still get the disease. But how is it reasonable for their concerns to outweigh the concerns of those who do not want the vaccine? Since the primary risk is to the one who decides not to be vaccinated, how can the government claim the authority to put their lives in danger against their will to minimize the already small risk to those who have already taken the vaccine? Are not forced vaccination the tyranny of the state over those who disagree with it? Is this not any different than the king that determines who will risk their lives in the name of his agenda? If you wish your state and the recommendations of some board of health to make vaccinations available for free in the name of the public good, I have no problem with that. However, when you claim the authority to endanger the life, health, and well-being of others against their will and solely for your benefit, then you have not only deprived them of your liberty, you have crushed the very idea of unalienable rights to life, liberty, and the pursuit of happiness. The biggest problem with our courts and the rest of our government's obsession with stare decisis is the simple fact that courts can get it wrong. Courts are made up of judges who are all human, and humans make mistakes. They can be seen in cases like the Dred Scott claiming that blacks were property, Korematsu that said you could intern Japanese during World War II, even the Kalo versus City of New London, where they said eminent domain didn't mean public use, it meant anything the public wanted. And that's just a few. By upholding the decisions of people without outside review, we have changed judges into oligarchs. We have rulers in black robes who cannot be questioned except by the others in their priesthood. And Jacobson versus Massachusetts is just another example. See, I do not find it reasonable to endanger the health and life of an unknown percentage of the population for the purpose of protecting others. Just as you do not have the legal or moral authority to force me to engage in a criminal in the process of attacking you, you do not have the authority to force me to endanger myself in order to protect you from a virus. If you are concerned about contracting COVID-19, the flu, or any other disease, feel free to protect yourself, included by taking a vaccine. But you do not have the authority to force me to take a vaccine in order to protect someone else. That is not reasonable, right? That is not defensible, either under the Constitution of the United States or of the several states. Oh, hang on, my screen locked up here. All right. See what you're talking about, it is the deprivation of a person's liberty, their property of their body, and potentially their life without due process of law. So before we go, there is one thing we have to remember. These laws exist because we have allowed our agents to pass them. If you do not want your government to have even the pretense of determining what you will put in your body, then I suggest you get these laws fixed in your own states. We should all take responsibility for our agents and hold them accountable to their oath of office, including protecting the rights of the individual. Okay, we had a couple bumps in that road, but that's kind of what I was talking about. A couple other questions here from my guy online. Let me take a look. So does anybody have any questions? I'm not sure if I can tell how many people are watching on YouTube. I am kind of new to YouTube and YouTube Live, I should say. So, anybody on the Zoom, if you're on the Zoom, unmute yourself, ask your question or pop it into the chat if you feel more comfortable doing that. If you are on YouTube, pop your question into the comments, and I will do my best to answer that as quickly as possible. See if we got.
Hey, Paul, this is Erin. Can you hear me?
I'm not expecting a huge audience because, well, I didn't advertise it on YouTube. I wasn't planning on it. It just kind of popped out in the last minute. Actually doesn't look like I've got anybody on the YouTube side. How about on the Zoom side? Any questions? And again, it doesn't have to be, whoops, I bet you I turned my sound off. I'm not expecting a huge audience because, well, I didn't advertise it on YouTube.
I don't know if you can hear me, Paul.
Yes, I can hear you now. Wasn't planning on it. It just kind of popped
Fantastic. So the thing that I've noticed in this talk, thank you so much. Thank you for talking over all this stuff that is so pertinent to every day, everything that we're dealing with. I'm finding in hearing you that there are so many layers to all of this, that you can pick out different points depending on what the speaking point might be, right? For instance, vaccines. Mm-hmm. But when you were talking about a question that came up for me when we're talking about like the Fifth Amendment and the 14th Amendment and stuff like that, is every law that is made dependent on, I don't know if dependent is the right word, dependent on the undergirding of the state and the US Constitution. So if that law is not in line with that, it should not stand. Is that correct?
I take it a step farther. Hang on a second. Let me see. The short answer to your question is yes. The answer is if you, and I'm bringing up a copy of the Constitution online because I want to make sure I quote it properly. But Article 6, Clause 2 of the U.S. Constitution reads, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land." So if you think of laws as hierarchies, right? You've got overarching, everything is the Constitution. That is supreme overall. Now, it's important to understand that the Constitution only delegates limited powers. So when it goes on to say that laws of the United States made pursuant to it, meaning to the Constitution, means only laws made not only by the process that the Constitution says, but within the powers delegated of the Constitution. So, Congress can't make a law legally that says, oh, I don't know, yeah, we can enter your house without a warrant. Right? They can't do, well, they can do it, but it's not legal. Now, under the US Constitution, if you're dealing with a state entity, the state has its own constitution. Now, remember, the states created the federal government, so states actually have more powers legally than the federal government does. I know we don't treat it that way, we don't act that way, but if you look at the actual law, any power, the 10th Amendment says any power not specifically delegated to the federal government, to the United States, remains with the states. So you think of it this way, the federal government has delegated powers in the Constitution. The states get all the rest, unless it's specifically prohibited to them. And so any law such as this, this vaccination law, or any law, any state law must survive both the state's constitution and the US Constitution. The problem we have is, judges and lawyers do not study the Constitution in law school. They study the opinion of other judges. And it's really like a big game of telephone. When I was a kid, we used to play telephone, right? You get a big group of kids in a room, and somebody would whisper something in one kid's ear, and he'd whisper it in the next kid's ear, and she'd whisper it in the next kid, and go on and on and on. And by the time it got to the other side of the room, it was a completely different message. Well, that's what's happened in our legal system. We went from, by the way, the Constitution is supreme and it means what it says, to, no, the Constitution means whatever the judge kind of says it means. And we have case law and precedent and stare decisis and all these euphemisms for basically putting the opinion of a judge above the Constitution of the country, the Constitution of the state, the laws of the country, the laws. Doesn't matter. The judge is going to overrule all of that, which is one of the biggest problems we have in our system. Is, in effect, judges are making law by interpreting the words of a law the way they want. Now, there's another very important point, and I want to make sure I get this right. I love Federalist number 78. Where's my Federalist papers? There they are. Alexander Hamilton wrote this. I actually did an article about this. You can, if you go to the website, constitutionstudy.com, if you look up Marbury versus Madison, I actually did an article about this a year and a half, 2 years ago. But there's a great sentence in Federalist 78. Where is it here? No, I missed it. It's in here. I know it's in here. I quote it all the time, but Federal 78. There he goes. This is quoting Alexander Hamilton from Federal 78. There is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is enacted, is void. No legislative act, therefore, contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than the principal, that the servant is above his master, and that the representatives of the people are superior to the people themselves. That men, acting by virtue of powers, may do not only what their powers do not authorize, but what they forbid. You see, we forget that every government in America exercises a delegated power. The Constitution of the United States delegates power to the federal government, the central government. The the state constitutions delegate powers to the state government. And in fact, I haven't proven this yet, but I've been told that each and every constitution, the constitution of each and every state, has the words that all power is inherent in the people and that they delegate it to government and therefore can oversee it. So we've lost this concept that governments and laws are subservient to their constitutions, that the people who make these laws are exercising a delegated power delegated by the people, therefore are confined within the powers that are delegated by the people, and that anything they do outside of that is void. And in fact, one of the more famous Supreme Court cases, Marbury versus Madison, where we get the vaunted judicial review, right? Lawyers will tell you that, oh yeah, Marbury versus Madison, it's where the court said that they could review each and every law. And that's not exactly what it says. Read my article. But even there, Chief Justice, I think it was Marshall, said that any act repugnant to the Constitution is void. Right? Now, the rest of the problem is, see, since most Americans don't actually read and study the Constitution, we don't realize that when a government passes a law, when a governor or a mayor issues an order that's repugnant to the Constitution, it's void, it's empty, it's vacuous, it has no value, it has no weight. So if you disregard an order that's contrary to the Constitution, you're actually not demonstrating, you're not being disobedient. You're actually upholding the law, because the law says that, well, you know, if that law is repugnant to the Constitution, it's void. Now, you may not have a hard time convincing the police officer of that, but that's what the law actually says. So
they're essentially waiting. They're essentially trying to make us believe that what they're saying is right and true and law, when in fact it might very well not be. So they're expecting us to be sheep and believe them. Is that essentially what it comes down to?
Exactly. I use the example of the emperor has no clothes, right? The emperor wandered around saying, look at how great my clothes are. Look at how great my clothes are. And everybody agreed with him until one little kid said, no, man, you're naked. Well, that situation we have here is these officials are saying, I have the power to do this. And everyone goes, yep. Some court said, yes, you can. We need to be those people going, sorry, no, you can't. I don't care what the judge says. The judge is human. The judge is subject to the exact same Constitution. Think of it this way. How can a judge supersede what the Constitution says when the judge themselves are subject to that Constitution? Article 6, Clause 3 says they must swear or affirm in their oath to support the Constitution. They are bound by it. They are subject to it. How can they turn around and say, nope, that's not what it says. It says something else. Because we, the American people, have let it happen. Does that help?
Yes, thank you, Paul. I don't want to keep taking over here, but it's
well, right now you're the only one here, so.
Oh, very good. Yeah, we I'm in Colorado, and we have
pop in.
And so we have a very we have a bad case of that right now. The governor says, oh, this mask mandate, it's a law. So you hear everyone parroting, oh, this mask mandate, it's a law. No, it's a mandate. It is not a law. It hasn't been through legislature. It has not been made into a law. But then you have people being, I wouldn't say harassed by the police, but kind of harassed by the police. You have businesses being shut down because the governor is yanking their business licenses because they are not forcing everyone to wear a mask inside of their establishment. And at this point, we're trying to get him recalled. Unfortunately, we have so many sheep here in Colorado that just blindly believe and don't even bother questioning. And it's, I hate to say it, but it seems a little bit hopeless.
Yeah, I know that. And you made a very good point. Mandates, executive orders, they are not law. They have not gone through the legislative process. Right. So you're absolutely right. They are not law. But here's the rest of the story. Right. And uh, you've got, I understand the situation you're in, right? You go to a place and these, you're right, these businesses are being harassed based on a mandate which is not legal because it violates the Constitution. They're being enforced. They're being threatened because we've gotten to a system where the state has the authority to tell you whether or not you can operate your business through a business license. Talked about that. But here, think about this. If I could make one recommendation, I would love all these businesses, all these individuals to do two things, right? First, can we find a law firm that is willing to take these cases, because it is a violation of US law for a state entity, any state agency, any state agent, to deprive a person of a right protected by the Constitution under color of law. So you're being these businesses, they're being deprived of their rights, their property of their business, their liberty to act as they see fit. When the government comes into a private business, they are taking over private property. We've adopted this myth that because they're open to the public, they're now somehow public access. They've got different rules. No, that's a private business. The owners own that business. They have a right to do with that business whatever they want. First thing I'd love to see them do is I'd love to find a lawyer that will take these cases. I believe it's 42 USC 1983. They can sue the individual as well as the agency for violating their rights protected by the Constitution under color of law. But here's what's better. Because finding a lawyer to do this may be a little difficult. Each and every one of these people should pick up the phone, call their local FBI office, and press charges under 18 USC 242, right? To be deprived under color of law of a right protected by the US Constitution is a federal crime. It is punishable by a fine and by up to 1 year in jail. By the way, if law enforcement draws their weapon, that's now a fine and up to 10 years in jail. We need to start using it's illegal for them to do that. It's about time people start filing charges. Try to recall the governor. Great. I want to see people start explaining, hey, the FBI just got a dozen, 2 dozen, 5 dozen charges filed. There are people pressing charges under federal law that you violated our rights. I'd love to see that in the news. So yes, and I know it's very depressing. I'm sitting here, it's me, myself, and I, right? You feel alone sometimes. I tell you what, I was up in North Dakota this past weekend. We had a bunch of patriots. We celebrated Midwest Freedom Fest. We had a bunch of great speakers, some great food, some awesome discussions. We need that basically to keep our spirits up, to recognize we are not alone. There are a lot of people that agree with us. We need to find whatever that percentage of people are who not only agree with us, but are willing to do something. So with that, even though it doesn't show up as Tunnel Lord, you're not showing up on my list of participants, Tunnel Lord has comments. So I'm going to ask some questions. So I'm going to answer his questions. All right. So what do I mean that rights in the Constitution are not absolute? Could I elaborate? Your right, there is one condition under which a government can deprive you of a right, and that is via due process of law. Right. So, for example, the classic example, right? People say your right to free speech is not limited. is limited. You can't walk into a crowded theater and cry fire, which, by the way, is not true. I have a whole article on that. But your right to be at liberty can be taken away from you as punishment for a crime. If you assault somebody, your liberty can be taken away. If you steal from somebody, your property can be taken away to make restitution. In certain situations, you can be deprived of your life, but it requires due process. It requires a process that protects the individual's rights. So when we're talking about, when I agree with the Supreme Court that, no, your rights aren't a carte blanche, there are very restrictive methods by which a government can deprive you of those rights. And in the case of the Massachusetts law, as I went through, they did not go through due process because they set up a system that did not protect the rights of the individual. So hopefully that answers that question. Another question. I remember you saying that oath keepers could be removed from their position if they don't uphold their oath to support the Constitution. Okay, I'm assuming you mean oath breakers. So there's an important point. Article 6, Clause 3 of the Constitution says each and every officer of both the state and local and federal governments, executive, judicial, and legislative, are required to swear or affirm that they will support the Constitution of the United States. They have to stand up and effectively swear before God or affirm before God, that's what an oath means, that they will support the Constitution. When someone fails to fulfill their oath, are they qualified for office? Right? Now, there's a couple different situations, right? Because the different branches of government have different methods of removal. We went through an impeachment process with the president. They talk about, the president can be impeached for high crimes and misdemeanors. Well, if he's under oath to do his duty and he fails to do that and he lies about that, sounds an awful lot like perjury to me, doesn't it? That's a crime. So they can be removed from office. Article 3 of the Constitution says federal judges serve during their good behavior. So if you are a judge and you promise that you're going to support the Constitution, but you regularly ignore the Constitution, and I don't mean you've got one opinion where you got something wrong. I mean, you regularly disobey the Constitution and infringe on the rights of the people in your court. Well, that's bad behavior, and you can be removed from office via impeachment. Now, it's a little different for legislators because where the judges are not elected, the president is elected by the states, not by the people. We now have both the House and the Senate are elected by the people. So the process of removing a legislative representative is a little different. And by the way, all the other officers are a little different as well. A congressman or a representative or a senator can be impeached. It's only happened, to my knowledge, once in this country's history. Why? Because each house, I forget which article it is, it's Article 1, I forget which clause it is. Each house has the ability to discipline their own members. So if I've got a representative who is violating their oath of office, why would I want to get both the House and the Senate to vote on it if all I have to do is get the House to vote on it? And the same thing for the Senate, right? If I have a senator that's violating their oath of office, why do I want to get the House to impeach him? I'll just get the Senate to convict him and be over and done with. The only difference between a removal, that method via an impeachment includes the punishment of not being able to serve in government again. So if you impeach an officer, part of the punishment is they can't hold any office of trust in the United States ever again at the federal level. The question is, what happens when nobody does anything? And this is where ultimately it's our fault. So follow this. We vote for members of the House of Representatives. If your House rep refuses to either file or work for articles of impeachment of another House member or sanction of another House member who refuses to follow their oath, why are you hiring them? We hire the people in the House of Representatives. They don't just magically take office. They win votes. They are our employees. They are our servants. So when I have examples of truly bad behavior, truly violations of their oath, then I go to my rep and say, part of your job is to hold these people accountable. Why aren't you doing it? I don't care, and usually they say, well, we can't win. I don't care. See, I don't judge you based on whether or not you win. I judge you based on whether or not you do your job. You're never going to win if you never try. And by the way, let's face it, we're dealing with politics. They already referred to Trump as an impeached president. Yeah, but he wasn't convicted. Doesn't matter. He was impeached. I would love to see some of these representatives, these kind of really out there representatives, ones that are really trying to take away our rights, going, yeah, that's an impeached representative. Oh no, they weren't convicted, but they were impeached. I'd love to see them removed. We have to hold them accountable. I tell my rep, listen, I'm really unhappy with what you're doing. I don't want to vote for you. I don't care if I'm looking for someone that will do the job, that will fulfill that oath. And I don't care if you're a donkey, an elephant, or a Martian. If you're qualified for office and you do the job, I'll vote for you. Now, that goes for both the House and the Senate. Now extend that to judges. I document, and I send these off to my rep all the time. I document the bad actions of federal judges a couple times a month, especially this time of year. I do it all the time. Wait a second, your job is to impeach judges who are behaving badly. That's part of your job as my agent, as exercising my power. Why are you not doing that? If you're not going to do your job, I'm going to look for someone who will. Now, all right, before I get there, that goes, by the way, the same thing goes for the president. If the president is violating his or her oath of office, it's still up to my representative, my agent, to be one of 435 members that looks at it and says, we need to do something. We need to represent our people faithfully. They don't for two reasons. One, if I may be cynical, because they don't mind that people are violating their oath. They just don't want to be blamed for it. Why would someone who how can you tell when a politician's lying? Their lips are moving. Why would someone who got into a job by lying want to hold somebody else accountable for lying? There's no advantage, because we, the American people, have trained our legislatures that the way to remain in office is not to do the job that the Constitution says, is to send home goodies. And as long as they do that, they're going to keep doing it. Ultimately, the responsibility, the buck stops here. It rolls all the way back to the American people and our unwillingness to hold our elected officials accountable. At the country centennial, James A. Garfield gave a speech, and I'm going to try and quote it. If the next centennial finds this a great nation, it'll be because the people require that of their servants. If it is an evil and corrupt nation, if we find our Congress to be good, it'll be because the people demand that. If it's evil and corrupt, it's because the people allow it to be evil and corrupt. Ultimately, it's our fault. Why did the founders allow you to stack the Supreme Court? Well, stacking the Supreme Court is kind of a loaded question, right? The Constitution allows Congress to determine the number of individuals on the court. All right. That means that the House and Senate together vote on how many seats are on the Supreme Court. Stacking says, I'm going to manipulate the process in order to get an outcome I want. Right? So that's someone manipulating the process. So when we hear people talk about stacking the Supreme Court, by the way, stacking the court is nothing new. Um, FDR tried to do it in the 40s. And in fact, John Adams tried to do it in the end of in the 1790s, late 1790s. At the end of his term in 1800, when he lost to Jefferson, Adams tried to stack not just the court, but the entire judicial branch, justices of the peace and all of that. That actually is what led to the Marbury versus Madison case, right? So it's not so much that the founders allowed people to stack the courts. The founders set up a system, said, listen, the people's representatives will determine the size of the Supreme Court. We are letting them stack the court. That's right. When you hear, and I'm trying not to use names or parties, but we all know who's doing this. When we hear people like, well, Biden and Kamala Harris talking about stacking the court, they're talking about manipulating the system because they can't get what they want legislatively. They're going to manipulate the system to get it judicially. They are violent. Actually, the statement stacking the court is a violation of their oath of office. Granted, they may be using the tools, but the idea of manipulating the judicial system to get an end other than what is done legislatively is a violation. You're basically saying we don't want these judges following the rules. Now, you could make the same thing. You could make the same statement. In fact, President Trump ran on the idea of, quote unquote, stacking the court with people who would actually follow the Constitution. So the term stack is value laden. We put a negative value on it because the people who want to stack the court, who want to give more control to their opinions on the court, disagree with us. But when people who agree with us want to stack the court, well, we have no problem with that. So, when we're looking at stacking the court, we're looking at people who are manipulating the system to get their own ends. To me, that's bad behavior. That's bad behavior in a judge. That's bad behavior in a representative. Trust me, if my rep or my senator talked about stacking the court, not only would they be hearing from me, but I'd be calling them out wherever I could that they are evil and criminal and aren't worth the trust of the American people enough to sit in that office. Okay, let's see. Any more questions? Those are my questions on the site. FEC. All right. So Aaron's talking about a group called FEC United. I don't know them off the top of my head. I'm familiar with several legal organizations. I am not a lawyer. Don't want to be. But to me, the point is, if we can find a lawyer, if we can find a legal firm that will start these cases, I don't expect the hard part is in the current situation, I really don't expect to win, which is sad that, you can have all the law on your side and you still can't win. But we won't change anything until we start getting people to see that there's a chance. Think of it. Early in the war, the revolutionaries, the patriots lost. They didn't actually lose a battle. They just didn't win any. All right. As soon as things started really going bad, they'd retreat. And Washington knew it was the end of, 1779, 78? I forget which. And he knows that most of the enlistments are up, right? He's got a few more days before the vast majority of his army can legally walk away. They've done their time. They've served their time. They can leave. He needs a victory. He needs something to light the fire to them again to say, yes, I will re-up. I will re-enlist. I will join this fight. We need the same thing. We need a victory, or at least enough of a victory for people to start seeing that, yes, you can fight City Hall. Yes, you can, if not completely win, you can protect yourself. You can at least make their life miserable. We need that Battle of Trenton. We need a Washington to cross the Delaware and to fight the Hessians, surprise them. We need someone willing to do that. And really, in the current legal market, we need a lawyer to help. Right? Washington didn't do them all by himself. We need someone willing to stand up and say, yes, I will sue so-and-so under 42 USC 1983. Yes, I will press charges under 18 USC 242. What we really need is lawyers that can help row the boat. We're on the wrong side of the Delaware. We need a few people that's willing to stand up and say, yes, I will do this. And then we need a couple of lawyers to come along and say, yes, we will help you because we find this that important. Because if we do that, if we show that we can win, and then we have to share that information. One of the things, whether it's Espinoza, the case I covered, when we win these little legal battles, we really need to shout it from the rooftops. We need to let as many people know as possible so that they can see that, yes, there is a chance. There is still an opportunity. We are not done yet. We don't have to break out the guns to protect our rights. We can still do it through the ballot box. We can still do it through the courts. We don't have to do it on the battlefield yet. We don't have to be standing there to defend our rights yet. But it's going to take a few people to actually stand up, say, yep, let's do this. It's a bold plan. We're going to try it. Let's do it. If you can get some lawyers' help, that would be great. And then share it with others. I was at Midwest Freedom Fest this past weekend. I would love to come to your city, to your neighborhoods, to your states, and talk with other patriots that are interested in their rights, in their liberties, in understanding what they are, and understanding how to defend and assert them, and opening this discussion to other people to say, you're not alone. So if you have an event that you think I might be interested in, go to the website, contact me through the website, let me know. If you would like me to come talk to one of your groups, I would love to. If you want to do something online, we can obviously do that too. Zoom works really, really well. But we can work something out. Contact me through the website. I'm already working on getting up to Pennsylvania. I'm trying to get down to Florida. I live in Middle Tennessee, so anything within a reasonable drive here is really easy to do. I'd love to come out to Colorado. I'd love to come out to these places because nothing energizes me more than meeting with other people that are just as hungry to understand the Constitution as I am, that are just as afraid of what this country is going to do to them and their children as I am. And to find those few that are willing to help stand up and do something about it. Erin says, yes, she is still continuing the battle cry and not give up. She's got it. She had to leave. I don't know. I get excited about this stuff. I had a great time out there. We're running a little bit. Well, I don't know if we're running long because I got a late start. By the way, you guys on YouTube, let me know how this worked out. This is kind of a last minute surprise. I was trying to do live on Facebook. Facebook wouldn't let me in, so I went up on YouTube. I've actually been considering doing a regularly scheduled YouTube live event. Would you be interested? Would that be something you'd like to see scheduled? Roof Korean says, will you run for Congress? My answer is, I will not campaign for Congress. I will not go begging for people's votes. But if there are people who want me to run for Congress, this is what you get. You don't get political platforms. You don't get nice work. Understand that if I run for Congress, I will not be part of a party. I will be neither Republican or Democrat, independent. I will be a true independent. I will have nothing to do with a party. I will probably be shunned in whatever circles that I'm there. The leadership of whatever house I may end up in will do their best to shun me and shut me up, because I'm not interested in the politics. I'm not interested in the games. I'm interested in my oath to support the Constitution. So to date, while a couple people have asked, no one's really tried to recruit me for Congress. And I'm not a politician. I'm not going to beg people. I'm not going to promise them stuff for their vote. If they want me in Congress, this is what you get. If that's what you want, let me know. So I don't know where you're based out of, Roof Koreans, but that's my position on Congress. So that, I think I'm going to wrap it up for tonight. I want to thank you for joining. I didn't get as many people on the Zoom call as I expected. That's the matter. But Tunnel Lord, Roof Koreans, for joining in without any warning, without any announcement. Thank you. I'm glad you got whatever notification you got to see this happen. I just think that's cool. Do me a favor. Let me know. Would you like to see a regularly scheduled YouTube live event? I'll be more than happy to set that up. Would you be willing to get other people to help join us as well, to share this information, to get them joined? Let me know. If I can get more people interested, I would love the idea. So with that, I'm going to thank everyone for their time. I'm going to wish you all a wonderful evening. I'm going to wish you the best. I'm going to hope that you will stay strong as we fight for rights and liberties in our country. And, keep watching the videos, keep getting engaged. And I hope to see you all later, and see you the next time on the Constitution Study. Have a great night.